I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time we run into Phil Barber, you should reach for.
And then I just looked at the jury, and it's sort of like,
I was in the eye of the storm. I was in the eye of the storm, and you guys were watching the storm.
hey, it's important work. Come pop in and say, hey, what's
You're a ray of sunshine. You're a ray of sunshine, and I love what you've done with your YouTube channel.
Hi guys, hello 13th jurors, hello. Can everybody hear me? Let me make sure my audio is set to what I need it to be. That should be it. Okay, hello friends, hello. I feel like I haven't been able to see y'all in forever, and I am so glad to be able to see you. Normally, you know me, I am streaming every single Karen Read everything live as it happens. However, today I had stuff I had for the project going on and could not do it live. So unfortunately, I had to miss doing it live with y'all. But I have not had a chance to watch it yet, so I did want to come watch it with y'all. I was in court today. For those who don't know, I was in court this afternoon. If you missed it earlier, it was Laurie Shaver's sentencing, and Kathy filled in as the hostess with the mostest. So thank you for running the stream, Kathy. If you hear me out there, I appreciate her stepping in and streaming so that I could be in court, but then y'all could also watch here together as a team, as a family. It was very interesting. The sentencing was interesting. There were a couple things that you couldn't see from watching it on the TV. First of all, Isabel and Travis both got there late. Isabel got there about 10 minutes late. And Travis didn't come in until maybe another 10 minutes after her. So for a minute, I didn't think that Travis was even going to come. But he did. He ended up showing up, and as did Isabel. When they gave her life, after Wiggs went on and on about trying to relive the whole trial and convincing the judge that it was a weak case and whatnot, after he went through all that hoopla for sentencing, the judge, of course, was like, okay, yep, gotcha, life in prison. So after that, when he said life in prison, what you couldn't see was, I noticed on the camera, you can see Wiggs talking to the judge, and you can kind of see Laurie like standing behind him, and you can kind of see like the top of her head kind of turn. But what happened was when her head turned, she actually turned to face Isabel, and she kind of smiled at Isabel and said, I love you, like mouthed, I love you to her. Because Isabel was sitting directly in front of me. And so I had a straight line of view to the convicted murderer. So there's that. Isabel did have some teary eyes when she walked out. She was there with, I think, three other girls that looked like around her age-ish. Travis had one guy with him. So they walked out and were there. I talked to the district attorney, the prosecutor, for a moment when everything was over, which is funny because he brought up the Karen Read podcast too. I was like, it's the case that never ends. the case that never ends. So, anywho, and then I was able to talk to Mike's brother, who is just as kind as he could be. He's the one who got up and read the victim impact statement from the family. So, I talked to Stacy. I texted her to ask her, which is Mike's sister, of course, and asked her how she was doing. She said it was emotional, but this is what the family was hoping for. This is final, like the final step in the justice process. So good to see it happening for her. Georgia Mom says, I was shocked no one spoke for Lori, actually. Yeah, funny you mentioned that. Lori sure did speak, not at the sentencing, but the letter that she wrote where she went on and on and on and on and on and on about how she's innocent and she's, just... they had tunnel vision and didn't even care about anything else and blah, blah, blah. So you can tell that she's very remorseful, right? Amanda Davis been for 18 whole months. Whoop, whoop. 18 whole months. Have we been here 18 months? That's crazy, right? Happy 18-month anniversary. Happy 18 months. Happy 18 months. Oh boy. Sandra Oliver, hello. I am happy to see your face too. Or okay, your screen name. I guess I don't technically see y'all's faces, but I picture your faces, but not in a creepy way. Tell us about your lunch and tea. Oh, me and Chat Daddy went and had lunch after the sentencing. I took Chat Daddy with me to the sentencing because I hate driving. So when I'm here, I am a passenger princess and Chat Daddy just drives me around, and that makes my life so much easier. He says he's the head of security for Brandy Churchwell Media. So he drives me around so I don't have to. So he went with me, which was interesting. It was his first time seeing kind of how all of this works, and, so that was interesting. So we went and had lunch at a beautiful restaurant right on a lake, not far from the courthouse when we left. And it was kind of like one of those weird moments. Like we talked about it. He was like, gosh, because it's a beautiful day down here. It's like 78 degrees or something, and just like beautiful. And he was like, this is crazy because, we're leaving the courthouse and it's this beautiful sunny day and we're going and sitting by a lake and having lunch, and she's going to spend the rest of her life in prison. And it's just kind of like this weird, so it's interesting, right? It's always, the sentencing is always like a big, like, wow moment, kind of. I don't know if wow moment is the right, kind of like you feel the heaviness of it, I guess is what you should say, or what I should say. So, but I am, oh, there's Stacy. Hi, Stacy. Hi, Stacy. We are so happy that we got justice for Michael. I'm very, I squeezed poor Chat Daddy. He was sitting by me, and when they said life, I squeezed his leg so hard. I was like, this is what we want. And I'm trying to keep I have to keep my composure, because I'm in direct line of the judge. So I'm sitting on the media bench and I'm in direct line of the judge. And so I'm trying not to be like, yeah. So I just squeezed Chat Daddy's leg. Like, he said life. So it was good. It was exactly what I was hoping for. And I'm glad. I'm glad for the family. I think this is, this is the next step to where now the trial and this whole process can kind of be put behind the family. And now it's like a new chapter where they can focus on healing and, and moving forward. So, and she has been sentenced to her forever home, and for that I am grateful. So Mrs. Saber for 13 whole months. I haven't been here because of YSL trial. We have missed you, but also I have been incredibly busy, so we haven't been doing many lives anyway, so it's okay. We are glad that you are here now. And I've heard YSL trial has been crazy. Heard it has been crazy. She deserves to spend the rest of her life there. Yes, she does. And she has no remorse. She has no, like, this letter that she wrote where she's just yapping on and on and on about how because you know, she's always the victim. She's always the victim. Oh, it just drives me nuts. Drives me nuts. Yapping on and on. I read it and then I was like, I have to take a break because she just keeps repeating herself and it's just more of her crap. And aren't we all sick of hearing from Laurie? Yeah. Raise your hand. Yep. Me too. She needs to get to her little forever home and shut up. Welcome, Lori Jean. Welcome, welcome, welcome. Glad to have you. Glad to have you. Lindsay Hendricks, hello. Brady the Glare has 2 dudes on right now who are in need of your charts and visuals. If you want to raid with your website real quick, because I forgot what for Karen Reed, it's 13thjurorpodcast.com. They're all on there. How long do you think it would take Travis to dump her? A year? Maybe less. Maybe less. You know, the letter that she wrote sounds almost kind of bitter towards him in a way too. So the sooner the better. The sooner he can get up away from that, the better, because it will be better for him, better for the kids. It'll just be better for everybody. So hopefully soon. I hope for that for them, and I pray for that for them. Camilla for 8 whole months. It's always good to get justice for the family. Yes. 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 It sure is. It sure is. Her smile today was driving me nuts. That's what everybody was saying. See, I only got to see her face after the sentencing. So during the entire thing, Wiggs was standing in my way. I didn't see her. But so I saw where everybody was saying that she was like smiling and laughing and people were pissed. But I didn't get to see any of that until, I didn't get to see any of that. I didn't get to see her face until after it was read, when she kind of backed up and made eye contact with Isabel, who was right in front of me. So I didn't see any of that, but I saw people talking about it that they were pissed. Yeah. Stacy says her letter was ridiculous. Yeah. I read it and I was so annoyed. And I messaged, I think I texted Stacy and a couple other people like in the families. And I was like, I want to make sure that y'all see this, because I don't want you to hear about this on the news, because she's lost her mind. And I want to make sure that, you know, that y'all see this. It's, oh gosh, she is something else. Oh, she's something else. Oh, that one. I remember when you first started talking about her a long time ago, and now it finished. Yeah, I know. It feels like forever, because I've been telling y'all about, like, oh yeah, my college roommate's, you know, friend. And like, so I started talking about this so long ago because I started following this before I even started the podcast, because of, you know, my friend's connection to Lori and Travis, knowing them because their kids went to school together, and, you know, being friends with them before she went crazy on them too. So yeah, felt like it was never gonna come. Hello. It's dark there. It is dark here. It gets dark at 2 p.m. Okay, well, that's an exaggeration, but actually because I'm at Chat Daddy's house, I'm in East Coast time zone, but when I'm just a hop, skip, and a jump over the time time barrier line thing. So I'm in Central. So it gets dark for me at like 5. It gets dark here at like 6. What sentencing are you talking about? Laurie Shaver. I was there today in court all day for Laurie. Not all day, just afternoon for Laurie Shaver. Hello and goodbye. All right. So that is the Laurie drama. She's something else. She's something else. Not a fan. Not a fan. But we are going to, because I was with them today. Thank you so much, Stacey. Thank you so much. And I got to talk to your brother today too, and he said the same thing, and I appreciate it so much. I was telling Chat Daddy when we left, I was like, it just brought tears to my eyes because there's no better compliment that you can get. You know, when I did the podcast with, you know, with that in mind, like wanting to tell the story and wanting to try to give a, you know, give a voice to Michael. Like there's no better compliment than to have the victim's family, you know, be happy with your work. So I very much appreciate it. And I am glad to have been able to work with y'all and make a bunch of new friends with y'all. So I appreciate it. I appreciate it. And Michael's, y'all, and if I never got to meet Michael, of course, but I've been able to be in touch with his family and his friends. And if he's anything like his family and his friends, then, you know, I know that he was amazing. And everybody just talks about him so highly and how he was such a jokester and he was so funny and kind, and everything that you hear from him, or everything that you hear about him from everybody who knew him, was positive. So, except for from Laurie, and look at her credibility. So we don't listen to Laurie. We don't listen to Laurie. So, I was honored to be able to tell his story. So, all right, so since I was in court today for Laurie Shaver, I missed the Karen Reed hearing, the trial that never ends, that never ever ends. The prosecutor in Laurie Shaver's case today came up to me and said, he even joked about that. He said something about my podcast is all Karen Reed now. And I was like, it's because it never ends. It's the trial that never ends. It just keeps going. And there was a hearing for it today. So it's not a super long hearing. I think it's only like an hour and a half-ish. So we are going to watch it together. And I have not seen it yet. So this will be, I know what they were arguing because I kind of know what was on the agenda for them. But I haven't actually got to watch it yet. So we're going to watch it together. And I've heard that the audio is pretty bad. I did hear that, but I have not. We'll see how it goes. We will see how it goes. Why don't I have my little? Oops, that's not what I wanted. I wanted to move. Oh yeah, this is what I wanted. There we go. There we go. Now we're rolling. Okay. All right. So here we go. This is, and let's just do it. You know what? Just for fun. Just for fun. We'll do. Playback speed, we'll do 1.25 and see how it goes. And see how bad audio is. Oh, we got a little bit of this is them not starting. There's Peg, let's see. Oh wait, here we go. All right, here we go. Here we go. Here we go. Good. So some of us will be watching this for the first time together.
Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally.
Oh, Lally.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. Carter.
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be in Zoom.
Okay, we can't see him though, Jim?
Yeah, we can't see you, is that? Okay. That's correct.
All right, good morning, Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hoc vice that you filed. And Mr. Unetti, I know these are...
Okay, pro hoc vice. So anybody who doesn't know, the pro hoc vice means that there's somebody who is an attorney who is not an attorney in this area, who doesn't practice in this area, who they're asking to add them to this area. So kind of the same thing that AJ did. AJ is an attorney in California, so pro hoc vice, they did pro hoc vice to have him added to the team so that he can practice in Massachusetts to join the team.
Freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay. All right. Thank you. All right. So let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
Wait, so she didn't... Wait, I'm confused. So she didn't... Did I miss that? So she didn't rule on that? She moved on to discovery. So did she not rule, did she not, those are always just those are always just granted. Oh, she doesn't, oh. She normally doesn't rule on anything, but those are those are always just oh, that's interesting.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind.
Okay. Or, just throwing out wild ideas, if you call as a 40-something-year-old woman, if I called my mama at 1:30 in the morning, which I have done before, it's not usually because I think that I have hit someone and have left them for dead. I have done so when I have been drunk and pissed off or whatever, which we saw that she was obviously pissed off, or not saw, we heard the voicemails to John O'Keefe that she was pissed off. So if she's calling her parents like drunk and pissed off to tell them about it, like, he's not answering and I think he's with somebody else and I'm here with the kids and what do I do, or anything like that, like, to me, that is, it's kind of a jump to just assume that because she's a 40-something-year-old woman and she called her parents, that means that she hit him. That's a stretch. For me, my opinion, I'm entitled to it. That's a stretch. But what do I know?
Is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there were no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. There were 2 search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Miss Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more.
I muted it because Lucy was barking, and now I have to start that whole sentence over again. I blame you. Going to the pound. Okay, let's start over. This is what I get for not being here for a while. If Lucy starts barking again and then I have to mute it and then I'm going to forget again. Watch. Okay. Anyway, this is the argument that he's making is, I posted this on X or Twitter or whatever it's called now. The argument that he's making, he misquotes what he says. He says that, that Mr. Reed said in his first conversation with Karen Reed that she said she hit something. And he's saying that that was at 1:30 in the morning. And that's not what was said anyway. He said in that conversation, he said, or in that interview, he said, Ted Daniel asked him in those first conversations, or in the, like, he says it's plural, as in not the very first one that you had, but as in your first conversations with her, the first times you were talking to her about what happened. So he misquotes this and he tries to use that as a gotcha moment by saying that Mr. Reed said that she said she backed into something, and at that point she couldn't have backed into the car. But he goes on in the interview to say that she backed into the car or whatever. So he misstates this to try to, or he misquotes it. He in writing misquotes it in order to try to get this pushed through.
That will be explored at trial. The time of the phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you?
Thank you, Nurse for God. Thank you.
Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e., Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was...
Her phone was sent to a taint team because Proctor's a douchebag.
...redacted from Ms. Reed's records. The idea of sending it to a taint team...
To be clear, that's not the reason, but it's part of the reason. It's sent to a taint team because she has privileged information on there between her and her attorney, and they have to remove and redact any of that privileged information before it's given in discovery, but also because Proctor is gross.
I surmise is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting of her records. And so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information in phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Okay, but also they're arguing to have Mr. Reed's cell phone records, but think about all of the records on the Rule 17 motions that were denied the first go around because of the privacy of cell phones and how it's a invasion of their privacy and all that stuff for all of the witnesses who were actually in the house when he was there. So if the court grants this for Mr. Reed for his records but not for all the other ones, that's gonna look pretty bad. Thank y'all to gifted memberships. Thank you.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but two separate sources.
Right.
The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's, and he wasn't present at the Waterfall on January 29, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone.
That's what I just said.
Using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden, to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete.
Yes.
I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29th, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m., after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of Lampron. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Lampron is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to...
That's his emotional support pin.
Paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Court. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
So before we move on to this one, I think that the whole thing with the phone records is, my whole thing with that is that I've kind of said the same thing that Miss Little was saying. Like, they have access to Karen Reed's phone records already. They have access to them through the downloads of her phone as well as her call records. So if they're trying to see if this is a one-off thing or a pattern that she calls her parents at 1 a.m, then they are able to look at that through her phone. So I think that, to me, when you look at the arguments that are made for the phone records of her parents as opposed to the phone records of the people who were in the house, if those are considered fishing expeditions and not admissible, then I would think that there's no chance that this would be, admissible. But it's Canton, so who knows?
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth, after review, to renew or reconsider the motion or the assent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, and Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing that was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, it was significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. The defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview?
Okay, so what he's saying about this, okay, so remember when they went through this whole thing the first time when they were looking for the records and they were redacted or whatever. He's saying that there's no, with the attorney talking to, even though their attorneys are on the record, it shows that their attorneys are talking to her, and that's changing the whatever he said, the content or direction of her statements, and that they want access to what's being said. It doesn't fall under attorney-client privilege because you waive attorney-client privilege when there's somebody else in the room, even if it's a reporter. So he's saying that they want access to all of the stuff that was said because those were her own statements, and it's not privileged information.
You have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or the attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, the Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement. Many of them admissions of guilt, contradictions, all of them. And the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. She said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car.
Okay, I'm sorry. He's never seen anything like this. Y'all know who he is, right? Okay. Sir, you are a lawyer for the mob and you've never seen anything like this when it comes to witness intimidation. Okay. Okay. Carry on.
It's repugnant. It undermines the fabric of the judicial system.
Okay.
But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case, she is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. In the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it and we take no exception for it. Thank you.
Yeah, he was
All right,
Whitey's.
thank you. Mr. Birch.
He was Whitey's lawyer.
Thank you, Your Honor. Robert Birch for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a
Okay, so this is the attorney who argued before the last time, before the last trial, when they the Commonwealth was wanting to get the notes and all of the stuff from Gretchen Voss's interview. So this is the same attorney that represented her before. He's now arguing why, I'm assuming going to argue his opposition to having to turn everything over.
Similar motion. And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed
Frozen?
did not have to be produced. And the Commonwealth has simply made no persuasive showing as to
Why is it frozen?
the decision should be any different now. The Commonwealth makes much of the fact that
I can
there
hear
are
it, but they're not
heavy
moving.
redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back even at the first trial? To come back and request it upon review of the first?
I'm sorry, I didn't quite...
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first? And what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook at time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. I've just already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called to witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did, because
on a
she was
daily
not on
basis.
witness list.
Right, on a daily basis.
I believe so. Yes.
Okay.
Every day. Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
And finally, the Commonwealth asks for the first time for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I've asked that we're willing to turn those over. They were not off the record, but I asked that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay.
And that's all I have.
All right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph. The paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started, your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Sure. We'll just wait right here.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far, it contains no damaging omissions by Reed. The audio provided thus far contains many damaging omissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position, that is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. And representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect, because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, and Ms. Voss, could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it. None.
All right. Thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? Okay. All right. So that is taken under advisement. Now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all three, but do you have different arguments?
agree.
A little bit different on each.
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the three? There are three motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay.
So here's the thing. So Massachusetts doesn't have shield laws, which means that, you know, if they were in a different state, then the reporters could say, or the station or what network or whatever could say, you know, you can't come after this because even though there's no attorney-client privilege, we have protection over it. But they don't have those shield laws to shield the Commonwealth from coming after the stuff in Massachusetts, because Massachusetts is a whole ass mess, let's be honest. So they're like how I'm in Florida, and like we have like the sunshine law where like it's easy to get court documents and, you know, public records and things like that. Massachusetts is like, no, you can't see any of our stuff, but you got to give us everything of yours. Massachusetts is the opposite of sunshine. So there is a chance that they could, you know, that Bev can come back and say that they have to turn this stuff over. They didn't do it the first time. We'll see what happens this time, but they're wanting everything. But keep in mind, he's wanting to do this because he's wanting to show that she contradicted herself. Bruh. Look at how many, like, have you seen your case? Like, there's so many contradictions in every single witness statement, every single officer's statement, there's so many contradictions. So I get that, like, trying to, like him giving the example of, like, oh, she said she was sipping, and then she said she was sipping water. Okay. Like, okay, my guy, your like police statements are all screwed up and times are changed and things are like, so I get where he's going with this, but at the same time, is the impact that he's hoping that it's going to have really going to be that effective when you look at how many backwards, you know, contradictions there are in literally every single police report and statement and witness statements and all of that stuff? I don't know.
And again, on these, Ms. Little, you don't expect to argue? No. Okay. If you change your mind, just stand up and let me know. No, that's fine. Okay. All right. I will hear you. Why don't we start with the FXT TV, Boston 25. It's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with...
Okay, he acknowledged... I should have watched this, and then I could, like, all the times that I've been like, oh yeah, like this and this and this, and had to stop it to pause, then they end up saying it. Okay, when I posted that on Twitter or whatever, like after this happened, and he's like, oh, okay, well, it said discussion, and it's actually with an S, but nevertheless, no, sir, no, not nevertheless, like that's a big deal, it totally changes the context of what you're saying and what you're implying, and it changes your gotcha moment to like a wah, wah, wah. So, no, you can't just like grace over that, like, oh, nevertheless, you know, like, just like, we're just going to just ignore that. And no, sir, that's a big deal. You wrong.
Did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all of his statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation interview was so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration, that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10, the position is that one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we're satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jim, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to...
427, Your Honor.
What is 427?
427, yes.
All right, so do you want to move on to CBB TV?
Yes.
Okay.
WCDB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB-TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business there. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in cases of objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being in another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That, I don't believe, is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that under that fifth paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired on 2020 Nightline, you hear oftentimes the author of the story, not even the interview, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not unsimilar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay.
Oh,
Mr. Albano, we'll give him a couple of minutes just to read it.
If that were Jackson or Yannetti,
Sure.
like all hell would break loose because they hadn't read it.
You want page 5?
Paragraph 5, it's on page 3. The pages aren't numbered. Actually, you should start at...
I've never seen this where an attorney gets up there and he's like, I haven't read anything. I haven't watched the trial.
4.
Haven't. You just read that. We'll just wait here, sir. It's her parents. And glare. Look at Will.
We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have.
Okay, so this is an interesting argument because they're based out of New York. So they're saying you have to go to New York because that's where we're based out of. And so if you go to New York and try to get this information, New York's gonna be like, nah, bruh, you ain't getting none of this. Like it's protected. But here in Massachusetts, I say here, I'm in Florida, y'all, but there in Massachusetts, there's no shield laws. So he's saying, so Brennan wants all of this to be handled in Massachusetts because he can get access to it in Massachusetts. But who is it? ABC, NBC, whichever one he's talking about. I forget now, but they're based out of New York. So they're saying you have to go to New York. That's like if you're trying to get something from a corporate office. If the corporate office is in another state, then you have to deal with that other state. You're not dealing with the store that you're, talking to here or dealing with here or whatever. Like if something is based out of a different state, then they're saying you have to go to that state to do it. And Brennan doesn't want that because obviously if you go to New York's going to tell you no.
To subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and shepherdize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material, so that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent, but that wouldn't change the domicile or citizenship of ABC. If there were a diverse plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts, or, for example, subject to taxes in Massachusetts. It's simply a way to make service a process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of, I think it started in Rhode Island, SJC case, and that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in rate contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that, yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here, does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information, not unpublished information, but I do think that. So I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Brennan? Thank you, Mr. Albano.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law, because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albano? Sure.
My first point is that we're dealing with a statute here. The statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCDB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC news programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay. All right, thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions.
Cameraman.
All right, so we have some housekeeping matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress for that. The Commonwealth's notice regarding the testing of the telematics system. Where do we stand with that, Mr. Brennan? I know you had said you told them that Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they're going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th. Okay. And they're going to do what's called the chip-on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car because there's different software which will give it even more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promise to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this. The the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had to go to a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the board's specific questions about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I expended many, many hours and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I have shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right. There are a couple of issues related to this motion, in addition to the protective order, that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
I haven't read this yet, so I won't know what you're talking about, Mr. Brennan.
So I believe you have read our motion, right? The motion that
I read your motion, I haven't.
Right, so it's just in relation to the motion, Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan printed this to us this morning.
Yeah.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they'd like to share it with, and I understand it's no prejudice.
This is for
Yes,
Morissey's.
and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used a personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I believe...
They're preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that...
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan conducted himself, he had searched for all emails sent from Michael Morissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed, R-E-E-D, which is how Mr. Morissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morissey in light of his actions using this personal email account to make an ex parte communication, and we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you.
Does that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion. And I'm going to do that. If they want to discuss how I can accommodate them, I'll do my best.
Okay. All right.
What in the Snapchat is going on here? Who has their phone? What district attorney has their phone set up to delete messages after 30 days? You know who does that? Liars, cheaters.
So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we drafted a planning and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here at the end of the week, so that's great. And your response by next week, Ms. Giannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay, so I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem. All right. Yes, Your Honor.
Yeah, if I can get it as soon as you can get it. All right. Anything else? Yes. That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Mr. Giannetti?
I expect I will, without prejudice.
I have material. I'll just wait.
Okay. All right, so if you sign it, then I'll endorse it, Ms. Giannetti. You had it, right? Ms. Little gave it to us just now?
I believe we just gave our copy to the court.
Yes.
All right, so this is the one that needs to be signed, and I'll endorse it. Do you want to take a look at it?
Yes.
Okay, I just pulled up a recipe on my phone this morning for my sister-in-law from a text message from like 2017 or something. So, okay. So the protective order means that they're wanting to protect the information that's being given. So like the information that they're getting from Morissey's phone, they're wanting to protect that in the sense that it's only to be shared with the defense team and the defendant. The defense team, including her attorneys and interns, like the people who need to actually work on it, and the defendant. It's not something they're going to be like get and like be like, hey, everybody, look at this. So that's what that's for. That eats good. Plus, I never delete anything either because I'm like, you know what? If I need to pull up what you said to me at 2:27 p.m. on January 31st of like 2004, I'm gonna have it ready.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Yes, Your Honor.
Just sign that and I will endorse it.
Thank you.
Okay. Anything else?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right, thank you, and I appreciate counsel and the third-party record holders coming in today.
12/12, 9 a.m. All eyes on the front, please.
All right, so December 12th, 9 a.m. is our next hearing that we have scheduled for this. So, interesting. What are we thinking? How are we feeling? Miss Little did a good job. Yeah, the only thing I have lost were on the BlackBerry era. Yeah. Yeah, same. And I'm really bummed about that because the last voicemail that I have from my dad where I can hear his voice was on my BlackBerry, and I don't have that anymore, and that makes me really sad. But I have voicemails that I have on my phone from my grandfather who is no longer with us, and so I have those on my phone. I don't delete anything. I don't delete anything. I don't even delete spam because if I need to know that you spammed me, I'm gonna pull it up. Interesting. Silver Swag says this was a fishing expedition. Amber Waves of... I like your name. This is ridiculous, yeah. The way that Karen and her dad are is very sweet. It makes me miss my dad. You can tell they're a close family. My in-laws are weird and delete their texts every day. How do you live? Like, how do you... How? You know, it's funny because I have so many red red notification things on my phone. Drives Chat Daddy nuts. Drives him nuts. He hates it. He's like, every time he's on my phone, he's like, how do you function with all those like notifications on? But I used to be one of those that could not have a red notification on there, but now there's no way for me to keep all of the notifications off. There's just no way for it to happen. I get too many, and at this point in my life, they're just gonna have to stay there. Is Lucy with me? Yes, she's over here. Here, hold on, let me turn the light on. Can you see? Oh, here. Can you see her? There she is. Hi, Lucy! Say hi! Say hi, big girl! Say hi, big girl! Say hi to your friends. Say hi to you're having a bad hair day, but that's okay. Say hi to your friends. Say hi. No? Okay. All right. It's okay. It's all right. Oh. What happened outside the courthouse? Do you know what happened outside of which courthouse? Outside of this one? I have no idea. I was in the other courthouse all day, so I don't know. I don't know anything that happened outside. Did something happen? We can look it up. Regina Crawford gets a membership. Thank you so much. Thank you. Thank you. Statement by Karen after walking out. Let me pull it up. Let's see. Let's see. What was it on? I hope so, because I miss doing trials. I'm hoping that things will calm down a little bit with the projects I have going on so that I can do one, because I miss it. What was it on? Do we know? I can pull it up. It was on Tom's CPU. Okay, let me look. Let's see. All right, let's see. So it was when she left the courthouse. Let me see. Gosh, it looks cold there. It was like 80 degrees here. Okay, there. All right, let's see. Let's see what she says.
All right, here they come.
Jonathan.
Yes.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
And are you you've been consistent in your story? Hey, guys, come on.
Good for you, Karen. You tell him.
Question. The judge not making a decision on the trial date, how's that impacting how you guys are prepping?
Well, we're just considering the march without preparation. We're going to be able to handle whatever comes our way, but we really hope that you'll fulfill the request. I think both sides realize it's in the interest of justice, so we're hopeful.
Is there any chance you meet you halfway and it's not April, but it's
Always a possibility. That's what happened last time. Oops, sorry. Just your thoughts about how all these sorts of things go. I really don't have any thoughts. Nothing went, that. Good job, Liza. Didn't expect. Good.
Jennifer Newsom says Karen Reed is 100% guilty. If she was factually innocent, she would turn over mommy and daddy's phone records and not be fighting it. Yeah, and also if the Alberts and McCabe's had nothing to hide, then they would have also turned over their phone records instead of fighting it, right? So kind of goes both ways, right? You can't really say that is guilty because they're not turning over phone records, because if you're using that as your logic, then that would mean that all of the people who were fighting to have all of their stuff not turned over, the people who were actually there, with a dead cop on their lawn, then kind of goes, right? Doesn't make sense to say. Actually, none of that makes sense. So we'll just keep on going. Her father said something too. Is that after that? Yannetti is a gentleman. He's. Oh yeah, they got new phones and destroyed their other ones. Correct. They are not her phone records. They belong to her parents. But see, the thing is that the parents' phone records are irrelevant because they already have access to her calling them, which is what they're saying that they want. And those are available on the phone records that they already have from her on the download of her phone and on her actual phone records. So it's all kind of a silly thing, isn't it? Let's see if is there anything else before we.
It's working through the issues. You know, there's nothing, no bombshells today. With this. Next, we have an evidentiary hearing on December 12th. You know, there should be witness testimony at that point, probably more lengthy than today, I would imagine.
How soon do you see the trial?
Well, we had a trial date right now in late January. You know, we're hoping that it's pushed off, but we shall see.
Mr. Unetti, what do you think they're fishing for in this fishing expedition?
You know, that's a question that's better directed at Commonwealth. You know, we believe they didn't make the appropriate showing and that the motion should be denied, but it's in the hands of the judge now.
Thank you, guys.
Okay, see you.
Nice.
She put it right back in the media.
Oh man, talk about in your face, Eve, huh?
She was like, "How about you?"
Look, you
Oh, hi, I'm the glare. Let me take a selfie.
All right.
Is that all of it?
All right. Peace out, bud.
All right.
Good seeing you. Thanks for coming by.
I think that's it. So interesting. This is the case that never ends, y'all. The case that never ends. Goodness gracious. Hello, Shittygram. So they already have it. They just want people to think she's hiding something by saying turn over a third party's phone records. They have the data from her phone. Yes, they have the data from her phone download and also her call records. So they have two separate versions of it, and they are still wanting more. So interesting, interesting. Can you answer that? Can you answer that? I am a very happy lady. Things are going good. The world is moving right along for me right now, and things are going great. I am in a good place. Got big projects happening that I can't wait for y'all to see and hear about. And I just realized, like, you can see my microphone in this corner, and I was like, what is that in the corner? It's my microphone. Big projects coming up. I can't wait for y'all to see and hear. And of course, as soon as I'm able to tell you, I will. All kinds of good stuff going on. All kinds of good. Podcast to Infinity from the Kierman case. It's the case that never ends. The case that never ends. It makes me so tired. So December 12th is the next hearing for this. I'm going to look after the holidays. I will be back at the beach starting Friday, and I'll be at the beach probably until Christmas, and then I'll be back here, I think the 26th or 27th, something like that. While I have a little bit of a break in between, Thanksgiving and Christmas, from the projects I'm working on. So I have a little bit of break from those. I'll still have to do the podcast, but I would like to see, I know there's not a whole lot going on around Christmas time. I would like to see if, we can definitely do some more lives during that and see what's going on. We'll definitely be doing the Karen Reed hearing on the 12th, because I will be home for that. I'm not going to have to be doing stuff going on during that. So we'll definitely do that, but I'm going to see if I'm going to take a look and see if I can fit something else into while I'm able to be home. So we'll see. Are we going to be seeing your name in the credits of something? Yes. And my face. And How is the kid? He's good. He's good. He has to work on Thanksgiving Day, which he's kind of bummed about. So we're going to actually be doing our Thanksgiving. We'll be doing Chat Daddy side Thanksgiving on Thanksgiving, and then my side Thanksgiving after Thanksgiving, because he's got to work. But he's other than having to work on Thanksgiving, which he doesn't really care. It's just a day. So we'll celebrate at some point, and celebrate means just go eat something. And he doesn't eat, like, turkey's not really his thing anyway, so we don't really do any of that anyway. Like, we'll just go get some fried chicken. Fried chicken or pizza. So, oh, there's Benefield sentencing and Boone next week. I should be able to do those actually, because I will be home. So thank you, Shore Life Creations. Let me make a note. And you know, if y'all have not listened, oh dang, I wish I could be here for Boone sentencing. No, I need to get home. If y'all have not listened to the Benefield podcast, there's 3 parts to it. It's crazy. I went on a deep dive, and I mean like rabbit hole deep dive, and that got crazy. So if y'all haven't had a chance to listen to that, definitely listen to it. Does Chat Daddy go and stay at the beach? Yeah, he does. He does. He loves the beach too. We're just back and forth, back and forth. Have the juror issue, was it resolved? They did have that juror issue, and I've been so busy I haven't had a chance to find out what the latest update on that was. So we'll take a look at that. We'll do a live on that next week. We'll do that. We need to catch up on that. Mermaid Mary RN, member for 11 whole months. Will you cover the on 12 to maybe I'll be home during that. There's only the 6th and 7th, which is on a weekend anyway. I've got stuff completely booked, but during the week when I'm home during that time, I may be able to do that. We may be able to do that. I'll look into that one, because I would love to be able to get a trial in while I don't have other project stuff going on. The only project stuff I have going on is that one weekend, like the 6th and 7th, or 7th and 8th, whatever that weekend is. Thank you, True Crime Ranch. The last one was good. It's the first one that I've done where it was just like the whole story in one episode, and I really liked doing that. I want to try to do more of those. I liked that one. The new podcast was on Naya Tao. It was a very short trial that we did. It was only like 4 days of testimony, but it was in Wisconsin. It was a triple homicide in Wisconsin, and I streamed it, we covered it, but it was a small trial, and it was kind of like one of those that we like fit in between some of the other ones that we were doing. But it was a very small trial, but it was really interesting and really sad. There were 3 victims who lost their lives, and so I did the podcast episode on that because it didn't have a ton of coverage, and his sentencing is coming up. His sentencing is actually on December 2nd. So. When is Sarah been going to her home? I don't know. We'll have to look. We'll have to find out. Thank you, Queen Oliver Than. Thank you, thank you. Thank you, thank you. All right, so I am going to call it a night. I am tired. It has been a long day, and I have to get up at 4:30 a.m. So it's going to be a very long day tomorrow. But after tomorrow, then I'll have a little bit of a break for at least a bit. I have heard of the Brian Camp. I have not had a chance to watch it, but I've heard it's pretty crazy. So I'd love to, be able to actually watch it and be able to see what all's involved in it. And maybe potentially that could be one in the future, because I've heard it's pretty crazy, but I have not had a chance to watch it. If y'all had any idea how just wild it's been. Everybody keeps saying like Chat Daddy's keeping me from y'all. I promise. And he feels like bad because he thinks that everybody's like thinking that he's Chat Daddy is not keeping me from you. It is, I am working on other things, but so I promise, don't be mad at Chat Daddy. He's not keeping me from you. I just have a lot going on, a lot of big stuff. It's exciting stuff. So, but I will be back. All right. Oh, good. Shore Life Creation says, happy Thanksgiving, everyone. Enjoy your family. If you are alone for the day, Baker is having a live. You can join him for company. That's awesome. I love that. I love that. That's great. It was not televised, the camp trial. Oh. KR trial wiped us all out. Yeah. I ain't been the same since, honestly. All right. I am going to go rest. Like I said, I gotta get up at 4:30. So I appreciate all of you. Thank you for those of you who hung out and watched with us. I'm glad I got to watch it with y'all. I'm going to take Lucy and Emmy and Tinsley out to go potty, and then I'm going to go lay it down for the night. So I appreciate all of y'all. Thank you so much. If you, Jim Cox, thank you, remember, for 3 whole months. It's your thing. Do what you want to do. See, I can't read that without singing it. I'm not a very good singer. That's okay. Watch Brian Camp's testimony on Court TV. 1.5 hour details. Oh, wow. Yeah, I want to go. I want to watch all that. I want to watch all that. Maybe it's something I can listen to when I'm muting. All right, y'all. Again, thank you so much. I appreciate you all. If you haven't hit the like button, please do so. And I will see y'all very, very soon.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?